I think one of the many virtues of Section 230 is that we don't have this discussion about active versus passive and how much involvement with the content becomes too much. We see that plaintiffs trying to allege it, but for the most part, we don't have that discussion in ways that solves, I think, some of the problems with the e-commerce directives. They're really hardwired in a set of technological assumptions about different ways that service providers would process content and set their liability accordingly. And I think that has worked out really well for us. As service providers have evolved, they've been able to continue to enjoy the immunity. And in fact, that was part of what I was mentioning in terms of experimentation. We see a lot more experimentation in that area on terms of how to present and organize content here for that very reason. The service providers feel empowered to do so. They don't have to fit into the forms that are codified into the statute. So I think actually it's really good here. I will also point out, though, that this is, I think, an example of, as Paul was talking about, where that's not really content that YouTube wants on its site. And so it's the kind of content that YouTube would very likely be one to remove without the statute, without any legal compulsion, because that's not the kind of service that they want.
The one thing in your question that disturbed me was the suggestion that it's different because YouTube, Google makes money off it. Well, so does the printing company. The Postal Service tries to make money even though it loses money on it. But the fact that it's commercial really shouldn't enter into the discussion.
Right. Well, yeah, I mean, I'm just telling you what the court ruled on. This is what they were struggling with, because Google itself said, well, there's no way we make money off of a bunch of kids bullying a classmate on a video. I mean, the court was saying overall it's a money-making venture, and you manipulate it in some way, and therefore it's not your host.
And Google's comment strikes me as rather silly. Of course they're going to. I mean, Google started out, like many sites do, they started out completely non-commercial, and then they found a way to make money off it by showing ads. And
I think we struggle with the commercial, non-commercial distinction generally in all aspects of law, and that includes free speech-related laws as well. So that's a catharsis that I don't think we're ready to have, because we aren't used to having micro-commercial activity.
Does that mean it's over, or that means we have to get ready to be over? We end at 3 o'clock. 5 minutes. Okay.
That was it.
Yes.
Thank you. From Europe. In Europe, the debate started around private forms each year, but sort of mixed. So I'll clarify one issue with you. The difference between the obligation to monitor the content actively, like in the Google case, and the obligation to react to either notice from the user or court decision. So what is your take on this one? I mean, are we clear that we don't want the positive obligation to monitor, while we might agree on the notice and take them as some kind of compromise, and we all would agree that reaction to court decision is enough? And one clarification towards US law, which I don't know that well. I understand there is no notice and takedown referring to defamation cases and privacy claims, but once the user has court decision, that can be effectively enforced or not than that?
My position is that Section 230 protects a service provider even against an injunction, even against having to comply with an injunction directed to the user. I mean, what worries me are, and we're in the process of writing an amicus brief in Maria's case, explaining these concerns. You have not only the problem of a user who just can't afford to defend, and so you have a default, you have the problem of the user who never really gets noticed because there's a lawsuit filed and it's in a jurisdiction 3,000 miles away where there really isn't personal jurisdiction. And of course, if it's an anonymous person, and so they pretend to make efforts to effect service, but they don't really make any efforts to effect service, and the trial judge is too busy to really pay attention to whether there's been an effective opportunity to provide a defense, and so you get a default judgment against somebody who's never appeared in court, and why should the online service provider have to comply with that if in their assessment it was really a sham proceeding? So that's what worries me about just the way litigation works in the United States. judges are so busy that when they get ex parte motions, they kind of just go along with them.
There's no way to effectively take the content down even the court.
Well, as I tried to suggest, most hosts, in fact, all of, to my regret, the message board hosts that I represent tend to just take down because, oh, a court decided that's enough. Maria's client takes a different approach, and I think Maria's position is defensible under the statute and as a matter of public policy.
The approach that my client has taken is that even if a court has determined it's defamatory, even if the author requests that it be taken down, my client will not take it down. Now, what we have not yet faced and what is yet to be seen is when the author defends it, the author appears and defends the statement and puts forward a true meritorious defense and loses. In other words, a true determination that it's defamatory. We have not actually addressed that issue yet, and when that issue comes up, my client will make a policy decision on what it will do. But I will tell you that from a legal perspective, my client's position will be that it has no legal obligation. But may, from a policy standpoint, look at that differently if it truly is a defended claim as opposed to these default situations that we've seen in the past.
I would point out most service providers actually welcome the court's adjudication because then they can rely upon that as opposed to trying to make their own independent adjudication. But we can see not all adjudications are equal, and so. But the answer to your question then is at least three of us are saying that the judge, that the service provider could refuse to honor that conclusion if they chose to.
Certainly would be the case in the UK. What I think also would be different in the UK from the US is, of course, that we have in English libel law, I understand elsewhere in Europe, in some jurisdictions as well, the presumption is that it's false, and it's up to the defence to prove the truth rather than the claimant to. And I know it's slightly different, but
very different.
And
I do want to clarify.
Isn't it also true that the intermediaries can be sued in Britain for a lot? The W.H. Smith can be sued for distributing a magazine.
Oh, absolutely. As if they are found to have sufficient awareness, and that's where we treat offline and offline exactly the same.
We have 1 minute left. Chance for one more question.
I was just wondering, so one of the things that you talk about is, as an intermediary, you're liable to provide both, like if a claim is made of defamation, when you're taking out the content, you have a service to be a responsibility towards the person who posted the information in the first place, and you have a service towards the consumers who are taking that information and maybe making wrong inferences. So you can say, since the service provider is making money off of it, they should be either investigating the information that is posted beforehand, or they should be investigating the claim that is made afterwards. So one of my questions would be, is there any research on what would be the economically, socially optimum amount of resources that the service provider should spend to provide a social optimum for all stakeholders? Okay,
let me pose you the instance of a service provider that gets 5,000 posts a day and has on their total service, they've got maybe 100 million posts. How much resources can they put into investigating even 1/10 of 1% of those? I would suggest to you that if there's any obligation to investigate, the result will be that you have an economically unfeasible business.
So that's why I said earlier they would go out of business. If there was a duty to investigate at that volume, they couldn't do it.
And if there's a post about me on the bathroom wall about my being willing to offer sex, should somebody be able to sue Georgetown for it?
But my question is, you don't have to investigate the entire volume of data, right? You can say that a reasonable investigation would be that you sample an X amount of data that is being posted on the website, and you can only or if a user, usually people who post on these places are people who post multiple number of times. So you can say that we sample an X number of posts that is made by that person, and that is reasonable investigation that is expected from the service provider.
It wouldn't help. You mean like an audit? I don't think it would help much because you're still going to have specific people that will say, I want mine investigated.
It's also not going to happen in either the US or the UK, actually. It's under Section 230. Of course, there's no obligation to do that. And in the UK, under the European regime, to actually impose a legal duty to do that would be directly counter to Article 15, which explicitly says member states shall not impose a duty of editing of that, and you would never get the intermediary community to agree to it either.
It's a policy question. It's not a question about what the law is. It's a policy question.
It's a fair question, I thought. I mean, the way I take your question is, could we set up an economic model to say, here's the amount of effort that should be invested before publication, here's the amount of effort that should be invested after publication? The answer, I think, is that not each item of content is equally valuable. And so, in fact, your model would have to account for the fact some posts will be very obscure and will be seen by very few readers. Others will be very high profile. And some items will involve mass market goods that have significant economic value. Some will involve niche goods, which don't involve a lot. And so if you were to construct that model, you could see that it would actually, I think, be very complicated to come up with a single number. And therefore, I'm not aware of any research that's been done to answer that question, and nor would I undertake that effort, because I think that in the end, I don't think we would be smart about what we should do.
I'm just curious, because under the Indian law, the intermediaries are responsible for the data that they either post or can't. So I was just curious.
And do you have consumer commentary sites in India?
I think we do. I mean, they must be. But they're usually sites that are posted in the United States. So all the takedown notices, like Wendy Shelter has the Gilligan Text website, so all the takedown notices come to you.
But isn't the answer to your question, isn't it obvious that under the regime, the legal regime in India, these kinds of sites can't exist? Because they're hosted in the United States, the reason they're hosted here, they couldn't possibly exist. They wouldn't be viable economically if they were hosted in India, given your law.
Well, there's no enforcement in
That just solves the problem.
I think that's an excellent call.
Why would the fact that it's hosted in the U.S. stop someone from prosecuting them if it's run by an Indian person and so forth? I mean, we've had things like that in the UK, which you can't really get away beyond a certain point.
The whole jurisdiction issue is a whole other hour and a half.
Yeah.
Thank you.
Thanks.